It is a pleasure to have you here today for the workshop on privacy-preserving machine learning. This is a virtual workshop co-located with CCS 2021. What is this workshop about? We want to have you here to present the latest research at the intersection of privacy and machine learning. And we have tried to get a workshop that has all of these aspects, like how to train privately, what are kind of the inference attacks that we can have, how we can defend from these inferences, new applications of privacy-preserving machine learning. And we have also tried to touch upon interdisciplinary aspects. This is the fourth edition of this workshop. In the past, this has been alternating between workshop co-located with NeurIPS and CCS, so that we can both tackle the audiences more oriented to machine learning and more oriented to security. And today, well, as you know, we are part of the CCS program. I'm very happy to having organized this with a bunch of awesome people: James, Aurelian, Adria, Olia, Mariana, and Philip. And I'm Carmela Troncoso. This year, we had 73 submissions, of which 41 were accepted. This is a 56% acceptance rate. We divided this in 7 contributing talks and 34 posters that you will be able to hear about today. And to select this, we had 45 PC members, out of which 7 were asked the organizers. So if you're curious how this went, every submitted paper got 4 reviews. We gave reviewers around 1 month to give these reviews. This was done in HotCrab. And then we had a 1 week of discussion. The discussion was online on HotCrab, where people were giving comments, and we were discussing which papers to accept. And the main criteria was novelty. As I said before, we aim to portray here the latest research on this domain, originality, and also the potential for discussion, the potential that these works had to spur conversations during these workshops so that we can push the state of the art forward. We also made a lot of effort in having topic diversity. As we said, like, we aim to be broad and to touch upon all of the possible angles of privacy and machine learning. So sometimes maybe we promoted one paper instead of another, just to make sure that we have a program that was really varied and we could touch upon all of the possible angles. You may also be curious why some papers have contributed tasks or posters. This is independent of quality. We actually wanted to have for each paper the best format that would enable them to show this whole potential of the paper and how to present the results. We asked reviewers to tell us whether they thought a particular paper would be better as a talk or as a poster, and then we chose the format that would help these authors to present the results in a better way and spur the more discussion. To complete the program, we have 4 amazing talks. And also here we tried to really tackle a varied side of topics, from the very interdisciplinary, with the first talk we'll have this morning on the legal side, to very technical, based on cryptography or on secured hardware, to also kind of the other side of what are the societal impacts of machine learning, or what happens with privacy when we use algorithms to do operations such as ad delivery. Because we are a virtual workshop, but we have people from all around the world, we have organized the schedule in 2 blocks. In the morning today, we're starting now, and we will be here until 12:30 approximately, and we will have 2 invited talks and 2 contributed talks, and then at the end, a poster session. Then at 5:30 p.m. for those in Europe, and I really don't know time schedule in the other areas, we will have the second block more oriented to people in Europe and in the US. And we will have again 2 invited talks, 5 contributed talks, and then a second session of posters. If you're curious about the exact times, please go to our website where we have when exactly each talk will happen. All of the talks would happen here on Zoom. And for the Q&A, you can ask your questions on the Zoom chat, or for those of you that are on Slack, on the PPML channel on Slack. The session chair of each of these talks will relay them to the speaker. And if you have more questions or want to continue, I encourage you to continue either on Slack or on GatherTown. GatherTown is the platform where we will have the posters. Here you have the link. You can also access this link from the main CCS website, the hub where you can have all of the links. The password is PPML21 because we're very original people. And when you get there, you will see the posters are organized in different zones depending on the topic. So try to find the zone that you're more interested on and find the posters in there. We will be recording the workshop, and afterwards we will make the videos available shortly after, depending on how long it takes us to process. All of this information is also on the website. We would like to thank our sponsors, the Anna Turing Institute and Google, that have provided us with funding to pay some registrations and also to be able to publicize and promote this workshop. And we would like to thank everyone that presented a paper, everyone that reviewed a paper and that put a lot of effort on these discussions. We would like to thank all of you attendees for coming, and also the CCS organization team for putting all of this up and make all of the digital means available, so that despite the fact that finally we have to go virtual, we actually have a lot of ways to interact. And we really hope that this is an interactive workshop. We encourage you to ask questions and to participate as much as possible to make this dynamic and enjoyable. And with this, I have nothing more to say. We hope you really enjoy the program that we have put up and that will have the best of the workshop. And with this, I think we can start setting up our first speaker today, who is Mireille Hildebrandt. Please stop sharing so that Mireille can start. We can again, we don't see the presentation, we see your full PowerPoint.
Yes, so this is the PowerPoint, right? So
yeah.
This is what you mean, right? Yeah.
Yeah, that's what I mean.
And I was still muted, sorry about that. So thank you very much.
It happens a lot. I mean, if we can wait 1 minute just to give people, because you're supposed to start at 20 past, just to make sure that everybody that wants to hear you
yes, so we wait
in the
2
room.
minutes.
Yeah, in the meantime, to fill the time, I can introduce you. We are incredibly happy of having today Mireille Hildebrandt, who is a research professor at the FRIA University of Brussels on the interface of law and technology. She also is the co-director of the research group of Law Science, Technology and Society Studies, and she also has a part-time chair at the, on data protection and the rule of law at the Radboud University in Nijmegen. And while doing all of this, Mireille has a lot of time to look at the implications of automated decisions and machine learning, and actually look at the intersection with the law and the rule of law, and how these two apparently disconnected topics, one very technical and one very legal, have come to become very entangled. And today we will hear more about this thing. Mireille has too many papers to be mentioned, and she's the receiver of an ERC advanced grant that actually works of this at this intersection of computation and computational computing and law, and has done a lot of work on this. So this is an incredible pleasure and privilege to have you here, Mireille, today. And we hope that our audience can enjoy a different view of machine learning when it comes to be sitting at a computer science conference. We're very used to have a very technical perspective. So thank you very much for taking the time today to be with us. And in 30 seconds, the floor is yours.
Okay, so I will slowly bridge the last 30 seconds. Thank you very much for inviting me. I feel very honored. Next to my chair at the law faculty, law and criminology in Brussels, I have a part-time chair, as Carmela told you, at the Radboud University. That's with the computer science department. And I feel very privileged as a lawyer. I've been teaching there for 8 years, law to master students of computer science. That has resulted in a book. And I often forget, I have to advertise that book, so I forgot again, I should have put it up on one of the slides. but it's very easy to find. It's called Law for Computer Scientists and Other Folk, where I try to explain as clearly as possible about what law is, what it does, especially also what it is not, what it does not, and how it is, why, but also how it is relevant for computer scientists. So today I want to speak about the need for fundamental rights assessments for machine learning systems, for data-intensive systems. And I'm very curious how this interacts with privacy-preserving machine learning. What I want to talk about is, when we're talking about PPML, what is the first P? What are we actually preserving? And I want to put forward the idea that privacy is about the protection of an incomputable self. And that may be, or it may seem, a very strange starting point, but I hope in the course of this half hour it becomes clear why that will actually help computer scientists to deal with issues like privacy. I want to briefly explain that further by talking about correlatability, linkability, profiling, and manipulation, and then link that to the requirement, the legal requirement of a fundamental rights impact assessment, both in the GDPR and in the proposed EU Artificial Intelligence Act. And I will finish by concluding that PPML may solve one problem and in the meantime create other problems. And that I think should be also a research agenda in this community. And I'm once again very curious how you look at that. To put the key message very briefly, I think that PPML protects individuals at the moment of constructing or inferring knowledge from big training data sets. But that at the moment when that knowledge that is being inferred is applied, it may actually create bigger problems because the construction is now more legitimate, precisely because it is privacy preserving. Let me explain. So what are we preserving? Privacy. What is privacy? Well, many people see privacy as privation, as being deprived, more usually traditionally, of the gaze of one or many other human beings. So this is about privacy as isolation, seeing human beings as atoms, thinking in terms of disconnection. Basically, this is what philosophers call freedom from. You can also say that privacy could be a provocation of returning the human gaze in such a way that you can see others, but maybe they cannot see you. And that's more about reaching out. It's more about acknowledging that human beings are relational beings, and it's more about what philosophers call the freedom to do things. And it's very important and interesting also for computer scientists to see that difference between freedom from and freedom to. The latter thing, freedom to, is more connected with the idea of privacy as control over information flows about the self. So this is maybe about the questions to share or not to share, and in more detail, what to share with whom, how, when, for how long. And of course, all this assumes that it is up to an individual to share, whereas I think much that a lot of data is actually not under the sovereignty of the individual, like if you apply for a tax cut for social benefits, if you want your doctor to treat you, you will have to share data. Things are more complicated than that. So I'm professing the idea that the core of privacy is being addressed as a person, and that means as an incomputable agent, as a person whose being a person is beyond prediction, is not just about similarity in terms of discrete attributes, basically highlighting the idea of individuality. Of course, the word individual comes from not being divisible. So basically, this already portrays the idea that we are in the end not computable. And I mean, the more romantic idea is about our singularity. So the singularity of each individual person. Okay, so what is this incomputable self? I've just said that the self, and when you think about the self, think about two things that are continuously interacting, and that is the I, that is the position from which I'm in this world, the position from which I'm capable, for instance, of doing computations. And the me, that is how I look back at myself. There is, of course, a paradox between the I and the me, because as soon as I'm trying to look at the I becomes the me, but it's again the I that is looking at the me. This is an interesting philosophical problem, but it also has many implications for the protection of this self. Now, the important thing that I want to share is that, yes, I think the self is indivisible and incomputable, but that does not at all mean that it cannot be made computable. And the core issue here is that we can be made computable in different ways. And how this is done, of course, makes all the difference. Machine learning systems are built on a certain research design. That research design involves a whole range of design decisions, and these decisions matter in terms of the kind of bias they enable, in terms of the kind of proxies they necessarily involve. And of course, a proxy makes certain things more visible and other things invisible. And basically, this boils down to an important point that I think any computer scientist is aware of, but maybe doesn't always have the time to look into, that any quantification assumes a qualification. Before you can add things up, multiply them, or do whatever mathematical operation or statistical operation on them, you need to decide, or you need your system to decide, what counts as the same. Otherwise, you cannot do any counting. And that means that a qualification necessarily always is assumed in any quantification. And those qualifications also matter, especially when we're talking about privacy. So privacy as a protection of the incomputable self maybe requires the reflective shield of Perseus. I shall not take you deep into Greek mythology, but do have a look at the myth of Perseus and Medea, where the shield basically bounces back the petrifying force. And now in my analogy, not of the human gaze of Medea, but of this computational gaze that tries to categorize us and make us computational. So rejecting computational qualification as this or that type of person should be seen as a core part of privacy. And that rejection refers to contestability also. So you can say, I'm rejecting that I'm reduced to this, but that's not always possible because a lot of decision has to be taken in a society. And in that case, when we agree as a society that we need those complications, we need to go to the next step, and that is to make a particular instance of that qualification and quantification contestable. So let's look at this whole domain of correlatability, linkability, profiling, and manipulation that is enabled by the application of machine learning systems. I'm not talking then about the construction, but of how they're actually deployed. Now, homomorphic encryption, multi-party computation, and differential privacy. And this is my maybe provocative statement, allow to ignore individual data points. And in doing that, they will enable privacy-preserving pattern recognition. At least that's the idea. So you are preserving privacy while enabling knowledge acquisition, and that sounds great, doesn't it? So they save against the construction of individual profiles, but they do enable entrapment by the inferred patterns in the future, because once you have those patterns, you can start applying that. So you can apply what we call group profiles to individuals that match those group profile. I mean something boringly obvious as all people with black hair are potential criminals. I admit a total nonsense statement, but imagine if somebody says they have inferred that, and maybe with many more qualifications, that would be a group profile. And if you can match that with an individual, you're going to predict something about that person, and that has all sorts of consequences. Now, if the profile is distributive, that means that the pattern applies to each and every member of that group, then that pattern is very privacy invasive because it allows detailed information about a certain person. And that information is then inferred from a population. And maybe you have protected the members of that population against privacy inferences, but once you apply them, the invasion will be very big. And we're not talking about privacy, of course, but also about other fundamental rights like non-discrimination and the right to an effective remedy, because you may not even have been part of the training set. You may have no idea how this knowledge was inferred and why it should apply to you. So that affects your right to an effective remedy, very important right. Without that right, privacy as a right is worth nothing. And the same goes for non-discrimination. So it's like a preconditional right. Now, group profiling that is based on non-distributive profiles, the example would be women have a chance of 1 in 8 to have breast cancer. This does not mean at all that each woman has such a chance, because the profile is non-distributive. Nevertheless, it allows for micro-targeting, though many of the inferences might be incorrect. So the accuracy of the profile that you have inferred around breast cancer may be 95%, but the precision may be 40%. And that's inherent in this sort of statistics. But of course, it has major consequences. It allows basically the infringements of various fundamental rights, notably non-discrimination, the presumption of innocence if this is used to target people in the context of criminal law enforcement, and again, the effective remedy, because you can't get your finger behind things. And it might be that this is even more the case with PPML. Now let's look at the fundamental rights impact assessment as it is required in the GDPR. And let's start with Article 24. Not many people talk about Article 24 because it's a more general, more basic article. It says the following, and I'm quoting, because I can paraphrase, but my paraphrasing the law has absolutely no binding force. Nobody is impressed with how I paraphrase things. It is the law itself that has binding force. And that is why lawyers find text so important. Taking into account the nature, scope, context, and purposes of processing, as well as the risks of various likelihood and severity for the rights and freedoms of natural persons, the controller, that is whoever decides the purpose of data processing of personal data, the controller shall implement appropriate technical and organizational measures to ensure, but also to be able to demonstrate that the processing is performed in accordance with this regulation. And this has to be reviewed and updated. Now here you see that this obligation, which looks like a fundamental rights impact assessment, let's say in a light form, has to be conducted always by default. Now you probably, I don't know, maybe you didn't, but if you have worked with the GDPR or taken note of it, you've probably heard of the obligation to do data protection by design and by default. That's Article 25. And that is a much more circumscribed and more in-depth requirement to do a certain type of data protection by default and by design. And it says, again, taking into account the state of the art, the cost of implementation, and the nature, scope, context, and purposes of processing. And here we see it again, the risks of varying likelihood and severity for rights and freedoms of natural persons. In that case, the controller shall both at the time of the determination of the means of processing and at the time of the processing itself implement appropriate technical and organizational measures, such as pseudonymization, which are designed to implement data protection principles, such as data minimization. And of course, pseudonymization and data minimization are core to PPML. This has to be done in an effective manner, and it must be the necessary safeguards must be integrated into the processing in order to meet the requirements of this regulation. And now it comes, and protect the rights of data subjects. So merely taking some little rules from the GDPR and trying to fix compliance at the technical level is not enough. In the end, the goal of the GDPR, Article 1, is to protect rights of data subjects. And actually, Article 1 says to protect the fundamental rights and freedoms of natural persons. So even not data subjects, we can be talking about third persons. Let's remind ourselves that pseudonymization is not in the law, in the GDPR, what it might be. In other domains, it is simply the following: the processing of personal data in such a manner that personal data can no longer be attributed to a specific data subject without the use of additional information. So the concept of additional information as core is with those, and that separation is there to ensure that the personal data are not attributed to an identified or identifiable natural person. It would be very interesting to raise and answer the technical question whether what types of PPML fall under this definition. And if something is pseudonymized, it counts as personal data, because as soon as you add the additional information, you have personal data, and that means we're talking about identifiable data. Okay, so Article 25.2 is about data protection by default. It means that you need to implement appropriate technical organizational measures to ensure that by default, only necessary data is processed, and necessity always requires a specified, explicitly specified and communicated purpose. And that applies to the amount of personal data, the extent, the period of their storage, and accessibility. So this is all about data minimization that has to be technically put in place by default. Now, let's look at the data protection impact assessment. So basically, if you read Article 35, which is data protection impact assessment, is about a fundamental rights impact assessment. And I'll go very briefly through this. Whenever you use new technologies, again, taking into account the nature, scope, context, and purposes of the processing. And now we get a higher threshold if that is likely to result in a high risk to the rights and freedoms of natural persons. So only in that case, the controller shall, prior to the processing, carry out an assessment of the impact on the protection of personal data. And the key issue here is that the anticipation that an assessment is about concerns, again, rights and freedoms of natural persons. Let's look at the proposed EU Artificial Intelligence Act. And in the preliminary text of the act by the European Commission. It says that this proposal imposes some restrictions on the freedom to conduct business, the freedom of art and science, to ensure compliance with overriding reasons of public interest. And these reasons, and this is important because these are the key goals of the AI Act. That is health, safety, consumer protection, and the protection of other fundamental rights, which is then called responsible innovation. And this applies whenever high-risk AI technology is developed and used. There is a classification, so there, chapter 1 of title 2 sets the classification rules and identifies 2 main categories. So on the one hand, categories of AI systems that involve a safety component or are as a product must be safe. So think of planes, medical instrumentation, connected cars, etc., IoT, smart grid. It's one set. And the other set is AI systems that have fundamental rights implications. So the first set we will find in Annex 2. I'm not going to talk about that. We're going to talk about Annex 3 briefly. And here we have a recital. A recital is part of the Act itself, but it's not yet an article. Let's not go into the technicalities here, but recitals are used to interpret the articles. The extent of the adverse impact caused by an AI system on the fundamental rights protected by the Charter, so that's the Charter of Fundamental Rights of the European Union, is of particular relevance when classifying an AI system as high risk. And here the recital cites the rights that are at stake. And this is about privacy, but it is also about human dignity, about freedom of expression and information, assembly and association, non-discrimination, consumer protection, worker rights, rights of persons with disabilities, right to an effective right to a fair trial, right of defense and the presumption of innocence, and the right to good administration. Now, I'm just going to walk through the set of high-risk AI systems that concern potential fundamental rights infringements. And I'm just going to walk you through it. I'm not going to discuss all these slides, but I will to give you a first impression of what this is about in the current version of the AI Act. So this is Annex 3. First of all, biometric identification and categorization of natural persons. So that's a technology, basically. So what is in red is like a categorization. The systems that are actually qualified as high risks are under that. So it's not all the systems that one could qualify as biometric identification and categorization of natural persons, but it's just the ones that are qualified as such underneath in black. In black, what is in black now, the Commission can add to that if it falls later after the Act is in force, if it suddenly turns out there's another system falling under such a category. So after specifying a specific technology, biometric identification, we now have a whole series, 7 types of categories where we find high-risk AI systems due to their potential fundamental rights infringements. I'm just going to quickly walk through that. So this is about critical infrastructure. It's about education and vocational training. It's about employment, workers' management, and access to self-employment. So we're also talking about recruitment. Essential private services and public services and benefits, law enforcement, migration, asylum, and border control management, and the administration of justice and democratic processes. Now, we can have lots of conversations about whether the Commission has got it right. I think there are a lot of things missing here, but we're not here to discuss that now. I think the structure and the types of categories are clear. So there are several indications of why and where in the AI Act this fundamental rights impact assessment is at stake. Here we see the article about transparency, and it is about transparency and provision of information to users. Now, the term user is the most flabbergastingly useless term because it refers to so many different categories. And in law, we're used to that. So this term user is defined somewhere upstream in the Act. And it's basically about those that deploy these systems. So it's not about end users at all. There's a lot of confusion about that. It is about those who deploy a system to target or to help end users, or to offer a service. And here it says high-risk AI systems shall be designed and developed in such a way to ensure that the operation is sufficiently transparent to enable the users to interpret the system's output and use it appropriately. Once again, we're talking about deployers of the system, so a hospital, a government agency, a web shop, somebody who is exploiting a web shop. And then it says that all sorts of information that must be provided to those users shall specify any known or foreseeable circumstances related to the use of that system in accordance with its intended purpose, but also when the system is used for other purposes for which it was not developed and not sold, but you can reasonably foresee that it will be used for that other purpose. And then the provider of the system has to anticipate the risks to health, safety, but also to fundamental rights. Also in Article 14, which is about human oversight, the provider of the system has to foresee all kinds of things to enable human oversight at the side of the user. That was the deployer of the system. And that human oversight shall aim to prevent or minimize the risks to health, safety, and fundamental rights. And again, the same thing, you have to, as a provider of a system, also look at not only at the intended purpose, the implications of that, but also where you can foresee that your system will be used for other purposes. You have to check that. Now, this demonstrates that within the jurisdiction of the EU, getting the future right is not only a matter of predictions via machine learning systems, but it basically requires a fundamental rights assessment. So around a year ago, the Fundamental Rights Agency of the European Union released this report, and you can read a lot of very interesting things about such an assessment. And very recently, this article was published. So you can see this is happening. Now, why is this relevant for this community? It is very relevant because it may be the case that PPML may solve one problem and create another. What if PPML is used to legitimize machine learning systems that basically enable micro-targeting in a way that could be discriminatory, manipulative, or incorrect? Think of the non-distributive group profiles. How do the different techniques of PPML interact with, for instance, trying to get system right in reference to other fundamental rights, so non-discrimination? So how does it interact with debiasing or with checking for bias? How does it interact with the verification and validation in terms of other fundamental rights, not only non-discrimination, but also the presumption of innocence, the effective remedy, freedom of information, and fair administration? And does that mean that new methods should be developed to check which type of PPML, homomorphic encryption, multi-party computation, differential privacy, or others, also thinking about ABC, attribute-based credentials, which methods best fits with checking for prevention of or mitigation of other fundamental rights infringements? So you can think of constraint programming, etc. Now, the big question is, why should you care? You could say, well, here you have your machine learning system. We have done PPML on it. Why don't you find somebody else to do some debiasing and don't manipulate with it? So you could say, don't just don't ask me, I'm doing PPML. I think that even if a developer, I assume that most people here are developers or system architects, even if you take that position, the controller under the GDPR and the provider under the AI Act cannot afford to say that. They need to anticipate fundamental rights infringements and avoid or mitigate them. And this is also another question for the providers, which are not necessarily the same entities. The controllers of the GDPR are probably the users in the AI Act, the deployers of the systems. A very important question, and that is question 0. Should the machine learning system or a system built on machine learning research design, the output of that, should this be used here at all? And one of my questions to you is, how do you interact with question 0? Does it inform your methodologies? Do you have any idea about it? Because I think it is actually a question that is crucial also for computer scientists. And this is the end, not of the world, but of my talk. And let me stop sharing now.
Thank you so much, Mireille. Virtual applause for you. Thank you for raising question 0. I really like question 0. I wish more people would ask question 0 more often. We have a couple of questions already. So Adria asks, could you comment on the role of mathematical rigor in formalizing privacy? You gave some examples of privacy notions that are really out of the scope for the kind of formal definitions we have typically on computer science, like the security given for homomorphic encryption or multi-party computation, or the definition of differential privacy. Do we need more definitions? Should computer scientists work on more definitions that encompass the kind of things you talk about? Or do we need a completely radical and different approach because this cat and mouse game is not working?
Oh, I love that question. I think it's a very important question, especially because it assumes that there is not one condition, formalization that defines privacy. And I think that's the whole point of my talk. So if you want to protect people's privacy, one way of formalizing is dangerous, because when you formalize, you basically make some things more visible than other things. And it may be that the real danger sits in the other things that you have just made invisible. So the more different, no, that's not true. It's not the more different formalizations we have, the better, because if you have 1 million, you're not going to help anybody. So the point would be to develop a lot of different formalizations of privacy. So to have like a toolbox of formalizations, then to throw out those that are absolutely useless. And I think you can't do that until you have actually made that bigger box. You don't know in advance, and maybe throw them out, but keep them at a second layer, because they might become relevant when things change. And then, of course, I'm advocating that when doing these formalizations, that you actually interact with the people of law. Like, there's so much confusion about what pseudonymization exactly means, that it would really help to figure that out in a discussion with lawyers, who will explain this is not about the grammar and picking up a dictionary to read Article 4 so-and-so of the GDPR, but about reading the case law and seeing what the courts actually decide. So I would absolutely applaud more definitions in interactions with probably both fundamental rights lawyers and the industry, of course, the people that are going to use these systems.
Great, thank you. So we have another question here in the chat from Edwig. Is your hypothesis of non-computable self-singularity really necessary? I believe this assumption is really popular in humanities background, but not necessarily enlightening for CS people. Statistics come with reduction and the inherent betrayal of reality richness. But in general, we, as computer scientists, will quantify self or any other analogic far too complex reality. Isn't it enough to acknowledge that we lose information and discuss when it is legitimate to do so? Talking about controversial. Go.
Again, I love that question because I think it's a question that people often don't speak. They don't say it, but that's of course what I think. And actually, to some extent, I agree with it. So you're saying whenever you formalize and begin to compute, you're losing information. We already know that it's nothing new. So this is exactly my impression, that computer scientists already know this. So indeed, I'm not telling them anything new. The problem is that when the system that they build are then sold by consultants or others who need to make a living, who actually don't know that at all, and who are super enthusiastic because they think if you compute something, it must be more true than when you don't compute something. And actually the question affirms that that is not the case. You're always losing something. And I'm going to say that terrible thing, the political question is, what are we losing and who gets to decide on the proxies? And both the proxies so if you decide to highlight certain variables, you're going to formalize and then you're going to say, okay, these variables matter here. Those variables that are considered proxies for, in this case, privacy. Yeah. That's the first proxy. It's a variable. We're still within mathematics. Then somebody else has to, and maybe it's your system doing it, but maybe it's people labeling. I recently read that IBM is using people in refugee camps to do their labeling for them. And they have to work very many hours. They get paid very little, and the situation in the tents where they are kept is not very conducive to, I would say, correct labeling. So the second step of creating proxies is when you actually decide that this thing falls within the scope of this variable. All these decisions have many implications. So maybe it would already help if computer scientists tell whoever is coming to fund or buy their stuff, look, we have to make certain decisions. We've now done this in terms of efficiency, but even efficiency assumes certain purposes. In function of what purpose? Efficiency cannot mean that on the short term it works very well, but on the longer term there are extreme externalized costs, and maybe for the most vulnerable part of a community. So I'm sort of in total agreement with the question, but contrary to the person who asked that question, it affirms the importance to recognize that whenever you formalize, you are indeed losing information. And that is because in the end, we are not formalizable or computable in an absolute sense. We are always more, and that is also connected with the temporality. So who I am at this moment is already different from who I am the next moment. And that may sound very obvious, but it has all sorts of complications because it's not only me that differs, it's everything else. So there is a complexity here of interacting, let's call a human person a system for a moment, of interacting systems at the level of individuals and various levels of society that make it very important to always understand that a system is not the same as the model of a system, etc., etc. I can go on for hours. I won't do that.
So we can take one more question very fast. We have Mohammed that asked that when the loss has not been likely identified, does the law also enforce how much likely is not acceptable, or is this led some kind of negotiation between users and providers?
Yeah, so again, this is a fabulous question. So I try to these days make a distinction between quantitative probability. If this were a question of quantitative probability, we could put a threshold somewhere and say, okay, we're going to say above 76.3%, it's highly likely. or above 76, the 87.8, it's highly likely, which assumes that you then have to figure out what proxies, how to formalize, etc., etc. Now, my position is that in the law, this is qualitative probability. That means we are ranking, we are not calculating. And as soon as you begin to calculate, you have to make so many decisions, you make things so ridiculously complex, and there's so many reasons to say, no, it shouldn't be 86.4, but 95.8, which are actually, anybody would agree with me, totally ridiculous here. And that means you're in the realm of qualitative probability. And there is very little literature about that. There is one emeritus professor in Berkeley who has a website up where he discusses this, a web page actually. And I would be absolutely delighted if computer scientists themselves would move into the domain of defining, probing, investigating the difference between quantitative and qualitative probability, how it affects these sort of decisions. And as a last thing, no, it is not up to users to negotiate this. Courts will make the final decision. So basically, users, in the sense of the deployers of these systems, will have to figure out and take seriously what is reasonable here and not outsource this to a metric that hides a lot of decisions instead of being transparent about them.
Okay, and with this, thank you so much for spending this time with us, and thank you for bringing a perspective that we rarely hear with so much clarity, and thank you for answering all the questions. And this will let you go. I believe that you have to be somewhere else. And again, thank you so much.
Thank you.